every tear for his remorse. Oceans you fill for yourself alone. Fluorescence and that now dethroned. So pity your river, not a drop for him. Your high ground's a shadowy wasteland. Samson night back with your selfish walls. No room for the tears, only you.
Hey guys, it's Mo, and on a purely vain note, can I say that I might never take this wig off? I am imbued with the confidence of no F's given Detective Great Hair. So I'm just saying that this might be my favorite wig ever. Deborah, I have not seen yet. I will try to keep updated on that. As far as I know, it will just depend. I know I have family members down in that area, and they say that they don't expect things to hit until Wednesday, but I will be keeping an eye on that. Right now, what we were going to go over for this stream was the motion to suppress the browse of justice said no to, but also we've got more inmate notes. We've got motions in limine that Jedi Jess was able to get us. So we'll be looking at those, but I figured we'd start with the motion because, well, I think Sarah was probably having a really bad day after she was also told that she couldn't get her glam squad in. Also, there's not enough Elizabeth Arden in the world to make that woman look sympathetic. I don't even know. She's not even an autumn or a spring. She's just unintentional. That wasn't on my card. No, I did not remember number 9 because my card was from 2013. So for this order, it is 10 pages long. Judge Cranick seems to like to really enumerate and ameliorate or be very specific in why he is making the choices that he made. It's interesting because I think his response to Sarah going pro se or making Sarah go pro se was 15 pages long. But he does like to have all of the receipts. He does like to have all of his reasonings, really clearly laid out. And I do appreciate this of this particular, judge. Have a great time. You deserve some relax and fun time after having to deal with all the, crud McCrud that you had to deal with the storms. So have a great time. So this is the order on the defendant's motion to suppress defendant's statements at OCSO, on defendant's amended motion to suppress defendant's statements at OCSO, and on the defendant's second amended motion to suppress the defendant's statement at OCSO. This cause came before the court on October the 2nd, 2024, on the defendant's motion to suppress defendant's statement, e-filed 9/24/2024, the motion on the state's motion to strike defendant's motion to suppress statements at OCSO, and the state's respond to defendant's motion to suppress statements, e-filed on 9/27/2024. Let's see here. The court, having reviewed the motion and having reviewed the response, having reviewed the amended motion and having reviewed the second amended motion, having reviewed the court file, having considered the testimony and evidence offered by both parties, having considered the arguments offered by the counsel for the state, and having considered arguments offered for the defendant, finds as follows. A. Defendant Sarah Boone is charged by way of an information filed 3/23/2020 with a single count of second-degree murder. B. On February 24, 2020, defendant called 911 after finding her boyfriend, George Torres, deceased. C. Detective Kayla Rodriguez arrived on February 24th, 2020 and spoke to the defendant. Also see State's Exhibit 1. D. Detective Kopsel, a homicide detective with the Orange County Sheriff's Office with 6 years' experience as a homicide detective and a law enforcement officer since 2013, was lead investigator of George Torres's death on February 24th, 2020. Detective Kopsel arrived at the scene within 30 minutes to 1 hour of OCSO's deputies, was briefed, performed a walkthrough of the apartment, and thereafter a search warrant was drafted. E. Detective Kopsel then made contact with the defendant outside of apartment for a few minutes and explained the procedures of a search warrant. The search warrant was executed with CSI. Defendant's cell phone was collected after CSI documented the scene. Detective Kopsel wanted to go through the defendant's cell phone to corroborate the defendant's story. Defendant signed a consent prior to February 24th, 2020 interviews addressed below. Also see Defendant's Exhibit 1. Detective Kopsel did not look at the defendant's cell phone, including any videos, prior to the interviews addressed below, as the digital forensics had not arrived until approximately 7 p.m. Detective Kopsel then made contact with defendant's ex-husband, Brian Boone. Their active detectives Kopsel and Lowen had an interview with the defendant in defendant Kopsel's unmarked Nissan Pathfinder at approximately 5 p.m. Also see State's Exhibit 1. Detective Kopsel explained that she wanted to have a conversation with defendant after walking the apartment. Detective Kopsel testified that she would not have interviewed the defendant outside the unmarked vehicle and had no memory of using the words routine, and that everything was explained on the recording. The word routine is not used by Detective Kopsel in any recording. See State Exhibit 1. Now, what I do really like about this judge is that he's showing that he looked at all the evidence, not just looked at the reports describing the report, but actually listened to and really took notes to see if, regardless of how petty I want to be, he at least did his due diligence and, tried to see if Sarah had any sort of point, which she didn't, but, he did try. F. Detective Kopsel explained the purpose of this interview, including the defendant's prior conversation with Deputy Kayla Rodriguez and Detective Kopsel, and Detective Kopsel's desire to get a, quote, further understanding of what happened last night and ask the defendant more detailed questions, end quote. See State's Exhibit 1. Thereafter, Detective Kopsel began reading Miranda, and then all 8 questions on Detective Kopsel's Miranda card were read by Detective Kopsel's were read as Detective Kopsel's Miranda card did not have question 9. So, Detective Kopsel, I'm going to read your rights, but it's just because that's how we do things, okay? So you have the right to remain silent, okay? Do you understand that? Detective Goodhair, I love you, but you coughed like the entire interview and it nearly drove me batty. Defendant, yes. Detective Kopsel, anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided to or for you before question without charge. Has anyone threatened you or promised you anything to get you to talk to me? The defendant, no. Detective Kopsel, do you understand what I just read to you? Defendant, yes. So even if she didn't use the actual verbiage of having all these rights in mind, do you wish to talk to me? This would be the colloquially almost the same thing. Again, she did ask if she comprehended and understood, everything that was just read to her. And Sarah then went into, her whole soliloquy of stupid. G. Thereafter, Kopsel interviewed defendant again after the initial digital recorder's memory was full. A second separate recording was initiated. During this separate recording, defendant used high-tier words, including corpus mentis. Well, of course, it's her favorite word. It's Latin for get out of jail free. Detective Kopsel confirmed with the defendant that no additional communications occurred prior to the second separate recordings, and Detective Kopsel inquired of the defendant prior to asking any other questions, quote, "Do you understand that you don't have to speak to me if you don't want to, correct?" To which the defendant responded, "Yes." Swifty, no, I do think that her sort of very unaffected, aloof personality wouldn't be someone that I would, particularly vibe with. But uh, that being said, I think it is the perfect foil for Sarah Boone. I think Sarah Boone hates nothing more than being ignored. Or not being listened to, not being responded to in the way that Sarah Boone feels that she should. uh, and what I mean by that is when Sarah was, trying to weave this sob story, Detective Greathair wasn't buying it. No one was buying it because, again, Sarah, for all of her use of Latin, cannot sell the sympathetic character that you need in order to actually, you know, pull off this battered spouse syndrome. We have all, I think the most gross part of this entire defense is that I think we have all known someone who had to, or ourselves been someone that has to get out of a really terrible relationship. And the fact that Sarah is trying to, in the spirit of Halloween, kind of, put our experiences on as a mask, I find very, very offensive. But that's just me. I still want her to get her due process. I still want her to have a fair day in court. But as a person, I think she's not really great. H, after concluding the interviews, but before leaving, Detective Copsell had conversations with the defendant about coming to OCSO next to address the pending autopsy, and that Detective Copsell would have more questions. Detective Copsell did not recall speaking about the defendant's cell phone, but had defendant asked about getting cell phone back, Detective Copsell would not have given a specific time frame for returning the defendant's cell phone. Detective Copsell had no memory of receiving a call from the defendant on the evening of February 24th, 2020. Now, I will say that this was an interesting part of the hearing because the way she answered this, like, do you have proof? Do you have the recordings? Do you have evidence that she called me? I have a feeling that there might have been a series of calls, but since the defense doesn't have, recordings of them, or Sarah is making stuff up, she played that well. She said, "Do you have, I mean, it's been 4 years. Maybe I did, maybe I didn't, but hey, what's going on here?" So that was an interesting, just sort of where she's like, "Maybe I did, but do you have any proof?" H, uh, let's see here. Defendant's testimony largely agreed with Detective Copsell's testimony, including the timeline of calling 911, speaking to Deputy Kayla Rodriguez, and speaking with Detective Copsell as to the February 24th, 2020 interviews. Defendant confirmed that Detective Copsell explained that general questions would be asked. Defendant confirmed that she stayed on scene 10 plus hours while the investigation was performed. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 1 p.m. the next day. However, there was nothing evidencing defendant being intoxicated or under the influence of alcohol when clearly speaking and interacting with Deputy Kayla Rodriguez. J, defendant's statement of making a call to Detective Copsell between 9:30 p.m. and 10 p.m. on February 24th, 2020, from her ex-husband's home does not line up with the defendant's own timeline of staying at the scene 10 plus hours, which began at approximately 1 p.m. The court finds that this statement lacks credibility. Judge Browse of Justice, I love you. He's like, this heifer is lying in legal terms. K, defendant claimed before they left the scene, Detective Copsell or Lowen returned defendant's cell phone to the apartment. On February 25th, 2024, defendant claims that defendant and Detective Copsell had a discussion regarding the pickup of the cell phone, especially that due to Detective Copsell's pregnancy, defendant would need to come down to OCSO to pick up cell phone. Defendant's sole reason to traveling to OCSO was to pick up cell phone, footnote 3. Approximately 1 hour and 27 minutes into the February 25th, 2020 interview, defendant returns to her list of pre-prepared written questions and specifically asks, quote, "Am I getting my phone back?" End quote. See States Exhibit 1. This was a prepared written statement or pre-prepared written question that would not be asked if someone was told to pick up a cell phone. Oh my gosh, the logic. The logic is great. I love this. I love this. He's like, huh, that's really interesting. Also, again, just showing that he did pay absolute attention. He did watch these. Welcome, Publicly Buzzed, and everyone. But these are logical, plot holes that if you lie a lot, if you don't want to tell the truth, you're going to get caught in these. Sarah is not compos mentis enough to remember what she said when she was apparently drunk, not drunk. L, on February 25th, 2020, after Detective Kopsel reviewed some of the extraction of the cell phone or the defendant's cell phone by digital forensics and attended the autopsy, Detective Kopsel requested the defendant to come to OSCO office. Detective Kopsel did not want to approach the defendant in front of her child at her ex-husband's home. Defendant's worry and concern about her son was addressed with Deputy Kayla Rodriguez, also see States Exhibit 1. Oh, she is? Well, so the last time when I did jury duty, the defendant was in when we were doing voir dire. So it's not actually that crazy, but oh, for the love of all that is flippin' holy, Owens, be careful with that one. That's a terrible idea, but let's see how it's going to go over. M, the state and defense agree that the February 25th, 2020 interview was custodial. N, the pith of the defendant's argument is contained in the exchange during the beginning of the February 25th, 2020 interview. Detective Kopsel, just let us know at any time if you need water, okay? I'm going to have you sit in the green chair. Detective Kopsel, I appreciate you coming in. Defendant, yes, ma'am. I wanted to ask about these when we have a moment. What is up with that little girl voice? Sarah, we all know you are a mega thunder cow. I'm going to say cow for right now, but mega thunder cow. Seriously, this little girl voice is fooling not one of us. Detective Kopsel, sure. So obviously he received his autopsy, and so I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it. Footnote 4. The court notes that this statement is an accurate statement of law. See Wright versus State. In Florida's 5th District, 2014. Quote, while Detective Stroop said, this is something I have to do when giving the Miranda warnings, this is an accurate statement of law, as law enforcement officers are required to administer Miranda warnings prior to custodial interrogations. So he is basically enumerating and underlining why none of this. Yes, the police should absolutely have updated cards. I don't know why she's wandering around here with like her Kroger ID card from, 2002. I don't understand why she didn't have a current, best practices Miranda card. But again, because the state or the Supreme Court hasn't assigned an absolute verbiage with which the Miranda warnings must be read, again, to kind of encompass all different educational and background sort of limitations. Yes, this is a fine way of doing it. It is, in fact, the law. We do, in fact, have to tell you this before you talk to us. The defendant says normal protocol. Detective Kopsel, just like we did yesterday, remember I read you your rights? Defendant, yeah. Detective Kopsel, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Defendant, sure. Detective Copsall, all right, you have the right to remain silent, just not the ability or the inclination. Anything you say may be used against you in court. See this entire trial. You have the right to talk with a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided to you before questioning without charge. Has anyone threatened you or promised you anything to get me to talk or get you to talk to me? Defendant, no. Detective Copsall, and do you understand what I just read to you? Defendant, yes. See State's Exhibit 1. Now, whether the Miranda warning was sufficient. Oh, quote, the Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Florida Constitution both provide for the right against self-incrimination. Tiger Inc. versus State, the self-incrimination clause of Article 1. So this just kind of goes on to sort of what the reasoning was and what a little blurb about the case. So let's see here. Florida Constitution requires that prior to a custodial interrogation in Florida, suspects must be told they have the right to remain silent, that anything they say can or will be used against them in court, and that they have a right to a lawyer's help, and if they cannot pay for a lawyer, one will be appointed to help them. Trailer versus State, Florida, 1992. P. Both the Florida Supreme Court and the United States Supreme Court have, quote, stressed that there is not a talismanic incantation required to ensure the Miranda warnings are sufficiently conveyed. So again, this goes back to this idea that they foresaw that detectives were going to need to explain this in the way that the defendants could understand it. So that means you have people who range from maybe not being able to understand, the written word. That's why they generally ask for educational background, things like this. Can you read? Can you write? And while it may seem offensive to some criminals, it's because some defendants can't. And they need to be able to convey this information in a way that each defendant will both intake it, process it, and understand their rights. The court does not examine a Miranda warning, quote, as if construing a will or defining terms of an easement, quoting Duckworth versus Agon, U.S. 195 in 1989. Rather, the inquiry is simply whether the warnings reasonably convey to a suspect rights as required by Miranda. Alterations in the original, quoting California versus Pressock. The crucial test for determining whether police gave a proper warning is whether the words in context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all his rights. Q. Miranda warning provided by law enforcement to the defendant at the beginning of February 25th, 2020 interview is sufficient under both federal law and state or Florida law. So these are, again, this might have had a point. Again, it goes to a terrible policy of the police not making sure that, we have the best standard, gold standard for all of our cards, HR making sure you have your, new Miranda card because we added a 9th question. This is, in fact, more of a do better, Orange County Sheriff's Office than it is she didn't get her rights. The Miranda warning given to the defendant is the instant case is identical to the exemplary Miranda warning identified in Owens. As such, the Miranda warning given to the defendant in the instant was sufficient. Whether the defendant's statements on February 25th, 2020 were coerced. Now, this is the other prong to which the defense is trying to attack this. And if you've noticed anything from Owens and Sarah before him, they do kind of use the scatter buckshot of, we're going to try this from many prongs and see if this works. T, to establish that a statement is involuntary, there must be a finding of coercive police conduct. Baker versus State, quoting Schoenwetter versus State. Generally, to determine whether a confession is involuntary and coerced, a state must examine the totality of circumstances surrounding it. Martin versus State. When the voluntariness of a confession is in dispute, it is the state's burden to prove voluntariness by a preponderance of evidence. Harold versus State. Thank you, observation station. They were out of Coke Zeros. I need caffeine. There were no misrepresentation of the law regarding any defense. See Johnson versus State. No quid pro quo. No directly or specifically made promises. No overt act or threat of force against the defendant was proved or claimed. Weish versus State. Florida 2008. No fear of material or physical harm. See Grant versus State. Florida 1965. Quoting Denmark versus State, no hope of material reward, no indication that the defendant was a newcomer to the law based on the 2 times Miranda warnings were provided between February 24th, 2020 and February 25th, 2020. No indication that the defendant is mentally deficient. I'll let you guys make your own choices. Especially considering the verbiage she used, no threats, delusions, deceptions, or promises, and the defendant was offered water and breaks, but was she given a Diet Dr. Pepper and a smoke? V, there were no false statements made by law enforcement in order to coerce defendant to go to OCSO's office on February 25th, 2020, based on the findings above. W, under the totality of circumstances, the defendant's statements on February 25th, 2020 were not coerced. Whether the defendant's statements on February 25th, 2020 were voluntarily made. X, a statement is not quote unquote compelled within the meaning of the state or federal law if an individual quote, voluntarily, knowingly, and intelligently waives his constitutional pledge. See Miranda versus Arizona. The state must prove by a preponderance of evidence that the defendant's Miranda rights were waived. Barger versus State, Florida 5th District, 2006. To constitute a voluntary waiver, the state must show 1, that the waiver was a result of a free choice on the part of the defendant and not a product of intimidation, coercion, or deception. And 2, the waiver was made with full awareness of the nature of the right being abandoned and the consequence of the abandonment. C, only the totality of circumstances surrounding the interrogation reveals both an uncoerced choice and a requisite level of comprehension. May a court properly conclude that Miranda rights had been waived? Yes, the problem is the fact that she was pretending to be she was a half-wit pretending to be a mid-wit, but looked like a dim-wit. The fact that she decided to pepper in these little, 15-letter words in here, corpus mentis, multitask, unintentional. She is negating her ability to use I was too dumb or too intoxicated to understand. She would be terrible at checkers. Why? Factors relevant to consider include 1, the manner in which the Miranda rights were administered, including any cajoling or trickery. See Miranda, Brewer versus State. The suspect's age, experience, background, and intelligence. See State versus SLW at Florida 1985, quoting Farr versus Michael, Dora versus State. In Florida 1980, the fact that questioning took place in a station house, see Drake versus State. The fact that the interrogators did not secure a written waiver of the Miranda rights at the onset, see Cellini versus State. So they have all these things happened as close to standard operating procedure as happens. And again, this whole coercion, the state was out to get me and entrap me. If that is if that is the thing we are going on, if that is your narrative, then why did the officers, even though she was the only person in the house, the only person that had access to that suitcase, let her go the night that they found George? Because they didn't have enough evidence. So you're telling me they decided to get all cocky when she had a snuff film and, take away her rights? She didn't need to say anything. They had plenty to arrest her. She could have said, "I'd like to speak to a lawyer," and they say, "Okay, stand up, put handcuffs on. You're going to the prison," or not the prison, to the jail, because they can no longer talk to her without a lawyer. So it is absolutely asinine to hold both of these divergent opinions at the same time and make them make sense. You can't. The court reincorporates its findings in, I'm guessing, subsection U and subsection V herein to further show no cajoling or trickery. BB, the defendant was 42 years old at the time, and she made statements and appears to be of normal intelligence. CC, the February 25th, 2020 interview did take place at, the sheriff's office, and no written waiver was secured. DD, under the totality of circumstances, defendant's statements on February 25th, 2020 were made with a voluntary, knowing, and intelligent waiver, and this waiver was the result of free choice on the part of the defendant and not a product of intimidation, coercion, or deception, and that waiver was made with the full awareness of the nature of the right being abandoned. So he basically just said, it's done. You're not getting this. This is not happening. Let it go. Now, we can already see that Sarah is not happy with this. And we have got the defendant's motions in limine. So let's see what Sarah would like to have not brought up at court. Now, motions in limine are basically motions made ahead of time. If you think of maybe the Daryl Brooks case, okay, motions are, we're not going to, talk about, or actually better, think of the Kyle Rittenhouse case. A motion in limine would be that they couldn't call the people who got unalived by Daryl, or not Daryl, for the love of Cheetos, Kyle Rittenhouse could not be called victims. That would be a motion in limine. This could have to do with conduct or different verbiage or different things that are allowed evidence-wise into the case. What judges do not like, and what Sarah Boone and Owens seem to really want to do, is to, have a trial by surprise, by ambush. Generally, both sides go in knowing exactly what the other side is going to say, generally. So this is the defendant's motion in limine. Defendant by and through undersigned counsel and under sections 90.402, 90.403, and 90.404 Florida statutes request this honorable court to exclude certain evidence at the trial of this case, specifically redacting portions of the 2-hour video interrogation at the Orange County Sheriff's Office, as the grounds alleged as follows. I am not sure. I'm going to go check on that. I will say that yesterday was kind of a crap pain day, so I didn't even look to see if it was going to go on. And I do need to look and see if the trial is going to be pushed back because of the hurricane coming through. So those are two things I do need to look at. But I assumed a lot of these cases, voir dire is not particularly covered, at least live streamed. I don't know if that's something that would be in a ruling from the judge. It does seem to go, back and forth. It does seem to be at the discretion of the judge or presiding over the case. 1. Defendant Sarah Boone is charged by way of information with a single count of second-degree murder. The offense allegedly occurred on February 23rd, 2024 in Orange County. No, it was 2020. Okay, well, they already have a typo in here, so I'm going to deny this. In Orange County. 2, during the homicide investigation, the defendant was asked to come by the Orange County Sheriff's Office. The defendant arrived on February 25th, 2020. Okay, this is why you need a proofreader, and was escorted into the interrogation room. A custodial interrogation of the defendant ensued. 3, the approximate 2-hour-long interrogation was recorded by audio and video. During the interrogation, the two homicide detectives questioned the defendant at length concerning facts and circumstances surrounding George Torres's death. 4, at such time, statements were made by the defendant and 2 detectives. Some of the statements made by the parties should be excluded and redacted from the video mentioned above. Oh, you mean like where Sarah said F you? And the officers were like, well, what does FU mean to me? Probably. I don't know. The first section of evidence to be excluded. 6, the following dialogue from pages 69, giggity, to 71, beginning on line 6 of page 69. Detective Lowen. Hold on. You had 2 different neighbors that lived directly next to you. You asked to use the restroom and they told you no and turned you away. You had to go. Sarah Boone. Oh, Detective Scott Lowen. Across the way to someone else? Sarah Boone. Oh, no. Okay. Kim and Eli. Eli or Kim is not a nice person. Detective Scott Lowen. Okay. Sarah Boone. She's just automatically not nice. Like, even after me and Lucas went over there and introduced ourselves, she's just not a nice person. Detective Scott Lowen. Why would you think she would let you use her restroom? Because Eli was there. Eli comes over and talks to us sometime, which I think pisses Kim off. Detective Lowen. Okay. Because he comes over and talks to us, the 2 of them, they're like super standoffish all the time. My neighbors down the street, by the way, their toilet was broken. They had stuff in their bathroom. So then their Detective Lowen, bathrooms? Sarah, like, go over there and try over there. Detective Scott Lowen, there's 2 bathrooms, so both of their bathrooms. I wouldn't let nobody go upstairs and use my personal bathroom. That's what the downstairs one is for. Detective Scott Lowen, or someone you knew, they're in the process of doing all this stuff in the kitchen. Okay. And there's stuff in the bathroom and the toilet doesn't work. Just move across the way. No problem. And of course they let me in. Them, they're together. They're like part of families. That's what you really want to know. I hope it doesn't get him in trouble. He's over here illegally, so he's trying to work on his green card. I mean, what an absolute mega thunder cow to go ahead and try to sick ice on people who didn't want you, in their bathroom. Sarah, I wouldn't I wouldn't let you into my bathroom either. Detective Lowen, what does that got to do with using the restroom? Sarah Boone, they didn't want to be involved. What's the address? That's Detective Klipsel. Detective Lowen, no. I was asking last night because, we had several different people. Assuming, Detective Lowen, stay in the neighborhood, come up. Eli and him saying that she was drunk on a regular basis. Eli and Kim, okay. Did you ask Benny next door? Those are the ones next door. And she asked to use the restroom and they said no. Detective Lowen, no, she said no. Okay, Detective Copsel. Like I said, she is not a good person. 7, the exclusion of said evidence is required due to lack of relevance under Section 90.402 Florida statutes. In addition, the evidence is improper character evidence under Section 90.404 in the Florida statutes. Second section of evidence to be excluded. 8 pages, or page 53, line 11, Detective Copsel. Well, he's dead as a result of your actions. 9, line 13, Detective Copsel. He's dead as a result of your actions. Line 11, or 914, Sarah Boone. I understand that. Page 55, line 24, Detective Scott Lowen. I I I have one last question. I mean, you realize you're the person that killed him, right? Then page 56, line 1, Sarah Boone. I thought about that. Page 92, line 15, Detective Lowen. Well, intentional or not, George is dead. You act like when you say unintentionally, that absolves you from everything. 14. The above evidence is improper opinion testimony by a law enforcement officer. Law enforcement cannot express opinions on the law or the ultimate issue of fact for a jury. See Odaya versus, oh my God, you guys, look. He's got a footnote. He's got a case citation. That's it. Stop the world. Stop the presses. We have finally got a citation of an actual effing, case that he can use to make his point. It's almost like he was a lawyer in one world. In addition, said statements assume the truth of the contested facts and encourage the jury to find the defendant guilty as charged because of a law enforcement officer said so. Alrighty. Owens, come here, my baby. Come here, little bitty Owens. Come here. Let me explain something to you. The jury is not going to listen to Detective Coffee McHot Hair or Detective McShiny Shirt. They are going to look at the snuff films. She caught it, on 1080p. Would you stop it? Would you stop it right now? And they're just going to presume she's a terrible person because she tried to get people deported. This is not going to work out for you. Nice try. I don't see it working out, but way to go. What a dingus. What a dingus. In addition, the statements assume the truth of contested facts and encourage the jury to find the defendant guilty as charged because a law enforcement officer said so. If this opinion evidence is admitted, the jury may assume the validity of law enforcement opinion because it was allowed in evidence and relies on the opinion in finding the defendant guilty. The issue of causation is exclusively the jury's job. This opinion evidence invades the providence of jury's fact-finding mission. I heard it and I can't unhear it. And how many other times am I going to say snuff film and it's actually appropriate, apropos, and well, will still probably get me, in trouble, but I still get to say snuff film. Scarlett, I do see that. What ticks me off, honest to goodness, about Owens, here's what ticks me off beyond the pale with Owens, is that he did no actual research into this case, into the sort of, let's say, the biosphere of this case. So he didn't even look to see how far up the, Danny Glover, like tired and ready to retire of this shit level of Danny Gloverness that the judge was. And let me just inform you, it starts at, Predator 2, Sweaty Danny Glover, and it goes all the way up to, Lethal Weapon 45, Why the Hell is Chris Rock in my movie? He is already on, Lethal Weapon number 45 level. He has no levels to go with her. So the fact that Owens got in and definitely thought that he could finagle his way to get a continuance or things like that, it is disingenuous. It is terrible. And why are you taking on a pro bono case? If you are, in fact, a practicing lawyer, if I were going to step into a case I knew that was 2 weeks or less than a month away from trial, I would want to know everything about this case. I would want to know everything about how the judge has reacted to certain things, to everything else. And he is just coming in and thinking that he's going to get a reset. And I'm sure that is what Sarah sold him on. I'm sure Sarah said, hey, if you come in, the judge will totally give us a continuance. It'll be 6 months. It will be fine. or she told him, hey, I am looking at taking a plea deal. Would you please help me? I think that they are both using this, and I think, unfortunately, Owens is getting used worse because we happen to have her. Oh, very cool. Thank you so much. So now what I will tell you about the jury selection is that what the judge, from what I gathered, is that they are going to start pre-striking people and have panels ready to go once the lawyers were there. So when I did jury duty, I had to sign in at 8, and the trial didn't even start until like 11. But we did, hey, do you distrust the government? Do you have, are you related to anyone on this case? Those kind of questions were already asked, and we were kind of pre-sorted out already. And apparently, in case you live in Indiana, the lower number you have, the more likely you're going to be on jury duty. I don't know who gave anyone the idea to let me on jury duty. I'm not going to read that, but yes, probably. Let's see here. The exclusion of any or all of this evidence described above is required as the value of such evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, and would only serve to inflame the jury. Wherefore, the defendants request this court to enter an order excluding the above statements from the videotaped interrogation in this matter. Now, I will say that this might go through. As much as I want everyone to know what a jerk Sarah is, the, trying to get people deported thing might not be great. Might not look it certainly sounds bad, but it might not play with a jury well. It might just, sit there and go like a lead balloon. But those things might be considerable. I want to see what the judge says about this. I think that it might be a little too late to do all of this editing, but this might be something that, is a fairly innocuous ask. Now, order regarding makeup and hair, the glam squad, Elizabeth Arden on steroids. Order on defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for the trial. This cause came to the order on October 2nd, 2024, on the defendant's motion for a right to hair, cosmetics, and civilian clothing worn or without restraints for trial, e-filed 9/27/2024. The court, having reviewed the motion and having reviewed the court file, having considered the arguments offered by counsel for the state, and having considered the arguments offered by counsel for defendant, finds as follows. A, the court provided an or tennis, I think that's what we said, ruling on October 3rd, 2024, regarding a defendant appearing in civilian clothing for trial. The defendant's access to cosmetics and hairstyling throughout the trial. B, the court reserved ruling on defendant appearing before the jury free of physical restraints. C, in deciding whether to physically restrain a defendant and what method to use, the court must balance its obligation to maintain courtroom safety against the risk, quote, that security measures may impair the defendant's presumption of innocence. See Dees versus State, Florida 1987. Quote, a court may only order physical restraints only if it is found to be necessary to maintain the security of the courtroom before ordering a defendant shackled at trial. The trial court must make a case-specific and individual assessment that considers, 1, the defendant's criminal history and nature of the pending charges, with special attention to whether it either involved violent acts, 2, whether the defendant has disrupted criminal proceedings in the past, and 3, whether the defendant has engaged in any threatening behavior. See Carlisle versus State. E, there was no evidence that the defendant has any criminal history. F, The defendant is charged by way of information filed 3/23/2020 with a single count of second-degree murder. G. There was no evidence that the defendant has disrupted criminal proceedings in the past or been contumacious defendant during court proceedings. H. There is no evidence that the defendant has engaged in threatening behavior. The court orders and adjudge as follows. The motion is hereby granted. The defendant's shackles and handcuffs will be removed during trial proceedings. Now, the whole hair and makeup stuff, the glam squad stuff, these are contraband items. These are things that people are not allowed to have in prison. And I don't know if Owens was, again, Owens says he is attempting to make Sarah more sympathetic, I guess more human looking, or Sarah has a gold tier, almost God tier, resting see you next Tuesday face. She has graduated from the echelons of resting B face, and she is right on the top of absolute, crown top tier resting see you next Tuesday face. No amount of primer, spackle, sanding, flying buttresses, God, the entire glam squad from RuPaul's drag show could not change that. Because when your soul is ugly, when your soul is mean, it tends to flow out and you get resting see you next Tuesday face. And of course, she rejected the plea deal because that would still require her to have some sort of accountability. And if Sarah Boone has gotten, 44 years without accepting responsibility for anything, I'm sure it's not going to change today. Because, of course, she is a gross person. Now, we get on to some interesting reading. We've got 10 more pages of inmate. Yeah, that's exactly. So now we have some more inmate notes. And yes, Sarah, I am using this for profit. I am, in fact, using you to show, how much of a dingleberry you are. Reindeer, she is not a smart woman. Again, it still requires her to have to absolutely admit some sort of involvement in her own failures. And she is too far gone with cranial rectitis. Her head is so firmly lodged up her colon, it's going to again have to do a lemmy winks up all of the digestive tract to get back up on her head. It's just, she is not a good person. And if she had any ability to read a room, she would have taken the plea deal. Now, let's see. A lot of these behavior inmate notes are showing for everyone to see that she was given her hard drive, her laptop, and all of this USB stuff, even after she was given a lawyer. She was still given all of these privileges to try to help with her own defense. So, for those of you who say I am way petty and too hard on Sarah, the state here is continuing to try to assist her to make her own defense. Now we get to an interessante little thing here. Very interesting. On 8/26, so this was on 8/26 at 4:52 p.m. I heard loud yelling from the hallways. Upon further investigating, I realized it was coming from the briefing room. The briefing room was occupied by inmate Boone and Owen James. Due to the loud disturbance, I entered the room and informed inmate Boone and Owens that they were causing a disturbance. Owens informed me that everything was good, that they had a little disagreement. After inmate Boone interview meeting, I spoke to her about retrieving a grievance form, but inmate Boone informed me she did not need a grievance form. Now, this is some interesting dynamic here. I find it very interesting that Owens is going to do it again. I have personal experience with this, but maybe not everyone has experience with this. If you are in a relationship with a person like Sarah Boone, usually the partner is the constant peacemaker, is the constant, wave smoother. Uh, the partner basically goes around walking on eggshells and making sure that no eggshells approach this person because we know that they don't handle eggshells. So the fact that Owens was, covering for her really confuses who is dominant in that dynamic to me. It really does say that Sarah Boone, for whatever reason, he's giving her cover. Now, I don't know if this was because, he is working for his client and he wants to make sure that his client doesn't have maybe bad press come out. But what I will say is this is a very odd dynamic for a professional and a defendant. Um, for them to be shouting at each other, for him to be excusing her behavior, saying, "Look, we were just having a little disagreement. It is okay. I don't want her to get in any trouble." Again, if you have been in this sort of relationship, you absolutely have been the wave calmer, the peacemaker, like, "No, no, he's really, really sorry. He didn't mean that. It was just, he has a temper, but it was a lot of things going on, and he really didn't mean to say that." Or, "No, no, we weren't fighting. No, it was a little disagreement, really funny. I mean, we just had, sometimes we can get loud." So that strikes me as incredibly odd. And even trying to do some of that kind of things I used to do, it's a weird emotional spot to be put back in when I'm talking about Owens and Sarah Boone. I don't think he understood what he was getting into in any sense of the word. I don't think that he was in any way understood the crazy he was inviting into his world. But him making excuses for her, this is what has happened in her life over the years. She has found her wave breaker, she has found her peacemaker, and she breaks them down to the point that they feel like there's nothing that they can do without her. She is the best thing that's ever happened to them. She's helping them because they're a diamond in the rough. And then you spend the entire, relationship, male or female, just putting out fires. "No, Sarah didn't mean to do that. You know what she's like. She just drank a little too much. We're working on it. She said she's going to go to counseling and we're doing that. But yeah, no, she totally gets that it's a problem. She just feels so embarrassed to talk to you and apologize, so she wanted me to apologize." These She has trained people around her to constantly excuse her behavior, and I cannot believe that she found a lawyer that's going to do this now. It is absolutely insane. Let's see here. Due to standard operation procedures and ACA accreditation, our monthly shakedown was conducted. Inmate Boone was afforded the opportunity to utilize her laptop at approximately 2100 or 2160 26 hours. So that is 11-ish. No, that doesn't make 9-ish. So a lot of this is just, again, documentation that Sarah, I mean, all these days she was given this, she has taken this. She was given a hard drive, she was given this, she was given that. It's very interesting that, I'm guessing, again, one of these buckshot defenses is going to be that she didn't have time to look at this to give effective counsel. Poor me, I, had to go through all these lawyers who weren't nice to me. And I guarantee you, you guys, don't quote me on this, but I am speculating if the trial starts going. Thank you, Roy. I was like, math is not my strong suit. if things start going against her, we are going to see beyond Shanda Vander Ark, we are going to see not even halfway subtles like he's a liar. I guarantee you when Brian is on the stage, she is going to be broadcasting in full color, HK, just high definition, just freaking see you next Tuesday vibes everywhere. She is going to not be able to control, to kind of regulate this. This is also the big issue Sarah is going to have with Detective Great Hair. Detective Great Hair would be a great poker player. Now, I don't have this ability. My face is bold, underlines, and all caps. But the detective doesn't show what she's thinking on her face. Sarah has never been able to do this because her smug disregard for everyone just oozes out of her pores. Roy, the bad thing is I am absolutely married to a service member, and I come from a family of service members, and I always forget. Let's see. The next one, the following behavior note is for informational purposes and stems from a telephone conversation had with Boone's legal counsel. So this was on 9/5/2024. On the evening of 9/5/2024, I had a telephone conversation with attorney Mr. James Owens. The phone call was prompted by several requests to schedule an attorney visit in the FDC's briefing room overlapped with on-shift immobilized face-to-ID head count and conflicted with the oncoming night shift's briefing as requests cited at an end time of 1800 hours. I do know that's 6 o'clock. Realized interview times were overlapping with head count or briefing times. I informed Mr. Owens that he could keep his pre-established interview times, but inmate Boone would need to return to her dorm by no later than 1650 hours and may not be returned until after the night shift's physical head count was cleared. During our conversation, I also inquired if any specific reason the briefing room was being requested versus the designated attorney interview rooms. When he said there wasn't, his preference was just the size and space of the room. I explained the briefing room was being operationally a necessary space, serving many functions outside of shift briefings. I clarified needing to have a discussion prior to any interference with operations and hopefully avoiding any appearance of attempting to impede inmate Boone's access to him or her trial preparations. I further informed him that we would do our best to accommodate his request on the briefing room, but to expect times where they may be asked to move to a designated attorney interview room. Let's see here. Mr. Owens acknowledged the information and stated he would have his office make future requests from 0900 to 1600 hours. I affirmed this proposed amended times were acceptable. I advised that though we appreciate his amenability, but reminded him that as an attorney, he is welcome to make his request for earlier than 0900 hours, but he may be subject to waiting until after the clearance of day shift's head count. This ended a phone call between Attorney Owens and myself. So let's see here. These go back in days. So inmate Boone is no longer pro se as she currently has legal counsel. Effective immediately, the laptop, charging cable, mouse, and carrying bag needs to go back to North Perimeter as she will no longer have access to these items. Captain DiGiovanni. In the brief prior to the start of shift, staff was informed of this directive from Captain DiGiovanni. At approximately 2010 hours, Officer Ivy called me from Bravo dorm to inform me that inmate Boone was demanding the laptop and threatening to have CCD held in contempt by the judge over her case for not providing her the laptop. Officer Ivy informed inmate Boone that the directive was from Captain G. Giovanni. Inmate Boone responded by stating, quote, "She does not have the authority to do that. It must come from a court order. You guys are in trouble." Oh my God, what a Randall. Let me pull. This is who she reminds me of. And 90s kids, you're going to get me. This is Randall. This is Sarah Boone, and Sarah Boone is a Randall, doing all sorts of shady, sus stuff. And then when the teacher comes over, "Oh my goodness, you won't believe what she did." Oh, she even kind of looks like Randall, not having thumb tab ideas or thumbnail ideas. No worries, guys. I am not and would never take Randall from Recess and superimpose Sarah's face on that. Just saying. I'm pretty sure I would. In fact, I will be doing that. I suddenly realized why I had an innate dislike of her. Again, you are in prison. I don't think you get to call to anyone's manager, but good luck with that. And yes, Sarah was on some Nickelodeon game show. It's weird and freaky seeing her before, years of bitterness and, well, just envy got a hold of her. I reached out to Administrator Sergeant De Jesus, who informed me that Honorable Judge Kranick was informed of this directive as well. Being that inmate Boone is no longer pro se, there was no objection from the judge. Inmate Boone was informed that her passive-aggressive behavior towards staff would not be tolerated. Should her behavior continue or increase, she could face possible disciplinary infractions. At approximately 07:35 hours, inmate Boone approached the officer's desk and asked if she could take a shower before her meeting at 0900 hours. She was advised that the dorm will be allowed to shower once the day room is open. She then asked what time that will be. She was advised whenever the day room is open, that's when inmate shower will be open as well. Inmate showers, inmate phone, and day room time tablets is available for any inmate starting at 0735 hours. At approximately 0937 hours, inmate Boone was issued her medication. Upon taking her meds, she was told to open her mouth and lift her tongue. Inmate Boone then stated, quote, "Do you want to ruffle my hair and shake my bra too?" No, no one does. What a cantankerous old sea face. Be advised, this is a common practice for officers to stop the inmates from storing or cheeking their medication. Ooh, this will be a long one. Okay, I disabled pro se alert for Sarah Boone this morning, 9/7/24. On 9/4/24, OCCD received communication from attorney James Owens' office. The correspondence identified Mr. Owens as legal counsel of inmate Boone and additionally requested to schedule the briefing room for a legal interview on 9/7/24. The delayed deactivation of the alert was in observation of a previous court order in place for documentation of access to electronic legal materials because the inmate's pro se status and requirement of a weekly submission to his office. Captain Di Giovanni was out of the office and unable to have a verbal conversation with presiding Judge Kranick until 9/6/24. When she disseminated instructions via email for staff to return the laptop to North Perimeter. The court was copied on the email, and Judge Kranick called Captain Di Giovanni just after 1600 hours on 9/6/24. Captain Di Giovanni explained to Judge Kranick inmate Boone could or would retain hard copies of legal materials, but because she was no longer defined as pro se inmate by OCCD's policy, she was no longer receiving a laptop, USB, external hard drive devices. Judge Kranick acknowledged Captain DiGiovanni, and the call was ended. I was present in the captain's office at the time the call took place. So, oh, for the love of goodness, she yelled at the daggone nurse again. Okay, on 9/4/2024, OCCD received a request for a legal interview from inmate Boone's legal counsel requesting legal interview with the inmate on 9/7/2024. Additionally, the correspondents request access to her electronic legal materials. Due to directive issued on 9/6/2024 to return laptop issued to Sarah Boone to the North Perimeter by Captain DiGiovanni, 3 USB devices and 1 external hard drive with connecting cord were turned over to Attorney Owens this morning upon his arrival to FDC, the scheduled meeting with inmate Boone. For documentation purposes, an OP-82 property and evidence chain of custody was completed for the 3 USB devices and 1 external hard drive. The form was filled out by Corporal Brown, who initially placed the devices in a sealed manila envelope, signing over the seal to show it had not been reopened. I signed the OP-82 upon taking possession of the envelope from Corporal Brown, and Attorney Owens signed the form after receiving it from me. I informed him and the court-appointed investigator present at the time that Sarah Boone would no longer have access to these items and that he may keep them. Let's see. Now, a negative officer contact. So, in case I didn't explain this, these are going backwards in time. So, the ones that were earlier were closer to present day, and these are further back. It took me a while when I was reading these. I was like, these don't follow cause and effect. And then I was like, oh, they're going forward to back. Naturally blonde under here. While conducting medication pass in B dorm, all inmates were given numerous opportunities to take their medicine. After announcing last call for medication pass, several inmates approached the nurse's cart to take their medication. As I was beginning to let the nurse depart from my dorm, inmate Boone approached the cart. I notified her that the nurse was preparing to depart. She became visibly upset and stated, "So you're just going to deny me my meds? You know you can't do that, right? I need to let a supervisor know you're not letting me take my meds." It is to be noted that while conducting medication pass, inmate Boone remained on the phone for the entire duration of it. After speaking with RN Alexis, it was determined that Boone would be allowed to take her medication. I advised her that her behavior would not be tolerated. Oh, awesome. Yeah, I will probably try to join in. I love how she thinks there's a manager in jail. I mean, like a manager that the inmates can go to and like yell at the guards. She's got a customer service line. She's like, "I would like to speak to your supervisor." What the hell? Okay, while conducting a visual inspection, inmate Boone Sarah was observed with staples in the seams of her pants. Her pants were immediately replaced with an appropriate fitted size medium, to which she began to complain about her appearance in the uniform she was given. Well, I mean, anything to make Sarah look slender. This is now the second documented time inmate Boone has been observed altering her blues issued uniform this way. She knew it was against the rules the first time because it was swapped out then too. I asked her where she was getting the staples from. Inmate Boone replied, "I got them from books that the chaplains gave me and from the books on the book cart. Y'all keep thinking I have some kind of special access to this stuff." So, Sarah Adams, what she was doing is, all right, we're going to have to imagine that these are pants and not a holy roller skirt. Well, all right, let's see what we can do here. So she's taking the side seam of her, like if she's taking her side seam of her shirt and like, ooh, I have a waist. Who knew? She's like, I am skinny, I promise. I'm like, well, yeah. Oh, thank you, Raj Vortex, for the update. It looks like that jury selection has been postponed until next Monday, October 14th, due to Hurricane Milton. So thank you for the update. I know that it is, maybe not what we wanted, but I want everyone to be safe. I mean, I keep seeing, I do morning newsy news. I do mornings with Mo and nightly newsy news. And apart from being a prolific news junkie, the stories have been just heartbreaking, of all of the people affected by this hurricane. And I'm glad that they're taking, the safe turn and not keeping anyone locked in a small room with Sarah Boone. Can you imagine going in for jury duty and then you're stuck in a courtroom for like days on as, Sarah Boone's like jury? I'd go out in the hurricane and take my chances. Not gonna lie, I would. But I love how Sarah's like, "No, I have an underbust. I promise." Let me un So Sarah's basically doing this. She's gathering the seaming and she's like, "No, I have an umpire waist." I'm like, "No, you're built like an umpire. There's a difference." That was mean. I'm sure there are beautiful umpires too. Roy, what I think would happen would probably be a hardship, sort of break. They asked a lot of people, not my group, I don't know why, but they did ask a lot of people, hey, do you have something that's going to stop you from being here? And some people had, transportation or that kind of issues. So, it was more of an issue with that. Let's see here. Well, she's still pissed off about her pants. This is now the, oh, there we go. Inmate Boone was advised, this being her second offense in altering her issued uniform, any further infractions would result in a disciplinary report. Inmate Boone stated she wanted a smaller uniform pants because the one she was issued did not fit properly. Well, darn. Learning that in jail you don't have your own seamstress. Sucks to be you, Sarah. Really sucks to be you. I remind her that the uniform is meant to simply fit and not reveal her figure. I informed her I would be placing a negative in her inmate notebook to be documented the repeated intentional violations of OCCD's rules and regulations. She proceeded to threaten me by stating she planned to file a motion with my name on it, to make that negative. So make that negative real good. What an ma'am, ma'am, I have you ever seen The Phantom Menace? You do not have the high ground. Anakin, don't try it. This is how you end up Vader Boone. What is wrong with this woman? Let's see. With the arrival of the lunch meal, I called for bottom tier of B dorm to come get their meals in bunk order. Inmate Boone knows she does not receive a special diet, yet she came to the table where the lunch trays were placed assertively and with what I perceive as attitude. Shoved her inmate ID close to my face, saying, "Sarah Boone, bunk 4, I did not get a diet tray." I am surprised she has not been subject to a blanket party. I mean, I'm just saying, I don't know that her attitude is not going to maybe result in some Gen Pop justice once she gets to real prison. Based on her demeanor, inmate Boone seemed to still have feelings over me replacing her self-modified blue uniform pants. You took away her pants. She is mad at you. Let's see here. Today, inmate Boone was scheduled for a visit with her legal counsel. At approximately 19 hours while passing the briefing room, I heard a loud noise followed by shouting. I encountered Corporal Pagan in the hallway and inquired about the source of the commotion. Corporal Pagan informed me that the noise originated from the briefing room. We proceeded to open the swing door and checked on the situation. Attorney James Owens acknowledged that he was the one who had yelled and expressed his apologies. I informed both Mr. Owens and inmate Boone that their interactions, regardless of its nature, was disruptive. Mr. Owens offered another apology, and then I exited the room. So let's see if there is anything showing up for Sarah Boone's hearing today. No, that's me. Oh, I love when I'm talking to myself through the thing because I'm like, oh, it's only my channel. Of course it doesn't have. Lord, I need help all the times. No, it doesn't look like there's anything up yet. I will be going on to look at stuff, but for now, we have some housekeeping stuff about the Sarah Boone case since we've gotten through kind of the current contemporaneous stuff. You guys are seeing my new overhead camera wire. I'm still. So, this is what I'm thinking. We've got project for Sarah Boone. I have several options. Not all of them are cross stitch, but I do have my new handy dandy camera as soon as I can figure out how to figure it out. So where we can look at this as I'm doing the court and craft part of this trial, if we ever get to trial. So we have the one and only Freddie Mercury cross stitch. Not sure how it in any way involves Sarah Boone other than, oh my God, it's Freddie Mercury. We've got the paint by number that Mr. Moe doesn't know I bought. So that follows the general Sailor Moon theme. Not gonna lie, everything that isn't Sailor Moon is either Freddie Mercury or Star Wars. So we've got this huge honkin' picture here that I'm not even sure what we're gonna do. I'm like, yeah, give me paint. Thank you so much, Sarah Adams. I know. Look, y'all, it is so vain, and I am trying not to be, super duper vain and full of myself, but I'm like, I'm never taking this wig off. I'm going to do a share too. I'm going to be like, I swear to goodness, I turned into Cher this morning, and Mr. Moe was like, what is wrong with you? I was like, oh my God, I'm Cher. And he's like, I don't even want to know what's wrong with you. And I was like, so many things, But I was like, I'm never taking this off. I just am not. Although the only sad thing is that I've lost my wig spray, so it kind of takes your hair and makes it a little sticky because I don't do the full lace insert. I'm not that coordinated or good at wigs yet, but I have no idea where that hairspray went. So I'm sure it will be probably not origami suitcases. But we have one final contender in the art project of Boonism. And no, I didn't find a suitcase, anything. I looked. So we've got one more contender, and this would be the obnoxiously large. Thank you so much, Publicly Buzzed. I know I have gotten the thing that I'm a little too snarky on these for Sarah, but I have, I think, at least well reasoned my my theory and why I don't like Sarah. I don't like, again, personally, on a personal note, having had to tell my two oldest daughters that their father was never coming home. The fact that Sarah doesn't even take that into her calculus, that Jorge lost his children, lost their father, it really does rub me the wrong way. And the fact that she is trying to, like, Freddy Krueger, wear the mask of some of really the most difficult and hardest times in my life and relationships kind of locked in that is really gross to me. She is just really gross. Now, our final and kind of what kind of what I'm leaning toward, and this is only because I bought all of the stuff, and if Mr. Mo is like, if you don't use this, you will get in trouble. But we've got this entire giant, hilariously sized diamond painting. I even have the little light up board behind it. So I will be putting these up on a poll on my community tab, and you can, you can vote for that and we can figure it out. I may also be taking time off to bedazzle my walker. I'm not going to lie. I'm going to be bedazzling the hell out of my Walker Moe's Ranger. Decided we're naming him that. So that is what we are planning to do. I am planning on update on a project that's nearly done, so I can give you an update on that. If you liked any of the cross stitch, I get my cross stitch from a site called Tapestry Market, and it doesn't only have Sailor Moon stuff or Freddie Mercury. I mean, that's what I get, but they have lovely other things. And they do have different anime too. So I think they've got Dragon or Demon Slayer and Pokemon and Disney, but I am nearly done with this particular one and just getting it done. They do sell both counted if you are that math smart, or the colored stamped ones, which I can tell you are what I'm smart at. But I'm nearly done with this one, so that's why I'm getting ready to, ask you guys' opinions on what the Sarah Boone project should be. So I'm nearly done with that. I just need to run to Hobby Lobby because I tend to waste a lot of string, not being strategery on where these things go. So absolutely, I will display this, and I'm going to be working on kind of moving my office space around to do to have an easier access. The transition between fall and winter is really hard for me. So just a couple different things to make this much easier for me to stream and be comfortable. So I've got a comfy chair, and we're working up how to teach me how to edit, because I'm really, really bad at it. I should be learning how to edit, but instead I'm like, let's cross-stitch Sailor Moon something. So I will definitely put those up. We know we've got Detective Goodhair, and we also have a Sarah Boone wig. So, and we have a Sarah Boone Ratchet wanting to be Detective Goodhair. This is all going to be sweet. I'm having so much fun. Thank you guys for joining me. I will say that I will put all of these project ideas on a poll either today or tonight, and then you guys can vote on them. And then I am not sure what we're going to be doing tomorrow because I kind of had this all set aside for Sarah Boone. And unfortunately, the other case that I'm following, the Delphi case, is even more close to the media than the Sarah Boone case. So I will try to be, I do need to get a satiny shirt. I think I will be going, I think I will be going to Goodwill to see if we can find a satiny shirt and a couple other things. I may even have Brows of Justice that I'm working on. I have way too much fun with me. Anyhoozle, guys, I am going to let you go. I do have a couple of errands to run, and I thought I was going to be doing Sarah Boone-a-thon all day, so I am going to take care of that and be back tonight for 7 p.m. nightly newsy news. I hope to see you guys there. We do a lot of the news, not so much politics, and definitely we try to stay out of the Mesopotamia. But we always, try to find the absurd things. Oh, awesome possum. I Yeah, definitely get your to be finished project, your project that you've hidden away, and we will do crafting in court as soon as Sarah comes back. And if not, I'll try to we still need to start going or finish going over Wade Wilson. So that might be what we do tomorrow for cross and court or court and cross stitch. I don't know. But I will definitely put something up tomorrow. We will have a ton of fun doing random stuff. And we'll just wait Sarah Boone to Hurricane Sarah will be, I'm sure, upon us very soon, whether we want it or not. So have a great day, guys. I will see you later. Thank you for coming by and talking. And, you know, I'm just going to wear this wig out for forever. Oh, you want me to explain to you how not to be charged with second-degree murder? That's a good detective hair day quote. Possibly my favorite, like, you're doing fine. Have a great day, guys. I will see you this evening. Be safe, be kind, and be caring where you can. And if people are jerks, screw them. Bye, guys.